we're going to go ahead and get started since we do have a lot to cover today. Welcome everyone to our webinar, Representing Afghans in Removal Proceedings. This webinar is presented by Clinic and Human Rights First. Before we get started, well, first we wanted to introduce ourselves. My name is Elizabeth Carlson. I'm a supervising senior attorney with Clinic. And I'm here with three wonderful colleagues, Rebecca, Corey, and Mona. If you all just want to say hello and introduce yourselves and tell us where you're from, that'd be great.
Hi, everyone. I'll go first. I'm Rebecca. I'm our supervising senior attorney with Clinic, and I'm based in Columbia, South Carolina, and I'm very happy to be here presenting with my colleagues and our guest speaker, Mona, which is great to have her here too.
Hi everyone, my name is Corey Hansen. I'm a senior attorney here with Clinic, and I'm based out of San Diego, California.
Liz, do you want to go ahead?
Did you want to say hello?
Okay, sure. Liz, if you'd like to go ahead. Hi everyone. So happy to join you. My name is Mona Iman. I'm a supervising senior staff attorney at Human Rights First, and just really thrilled to be here today.
Wonderful.
And I'm based in Los Angeles, California.
Great. So just in terms of some housekeeping details, please put any questions that you have into the Q&A box. We will do our best to answer them. We do have a large group today, so most likely we're not going to be able to get to every single question, but we will keep an eye on that Q&A box and again, do our best. Chat box you can use. I see a lot of you saying hello to each other. That's great. We might ask for some feedback today throughout the presentation in terms of, trends or experiences that you all are having in your representation. So you can definitely use the chat for that purpose. So in terms of our agenda for the day, we are first going to start off with kind of talking about different manners of entry at the US-Mexico border with a focus on Afghans. Basically, we're sort of going to be talking about the distinction between those who are, paroled into the U.S. under Section 212D5 and those who are granted what DHS calls conditional parole, and sort of why that distinction is important in certain cases. We are going to then turn to talking about Afghans in detention, and that's where we have our wonderful expert, Mona, who's had a lot of experience representing Afghans who are detained. We're then going to talk about representing non-detained Afghans, particularly with a focus on asylum applications, sort of the merits of the applications, navigating bars to asylum, as well as, of course, with the recent redesignation of TPS, what is sort of the intersection of asylum and TPS for Afghans. And then finally, we're going to end with talking about some strategies to expand representation of Afghans in removal proceedings. This is an area we would love to hear sort of your feedback and your thoughts on this, because we know that there is a current lack of representation for this particular population in removal proceedings. All right, and I will turn it over to Corey to talk to us about manners of entry along the US-Mexico border.
Thank you, Liz. Okay, so first we're going to take a look at the various manners of entry and then the corresponding documents that you'll see depending on when, how your client entered, and then briefly look at the implications that each manner of entry is going to have, the legal implications on their case. So we're going to look at the two different types of parole. As we know from the recent BIA case, conditional parole is not considered true parole, but it is something issued at the border. It's going to have a different set of documents that goes with it than humanitarian parole. But let's first take a look at humanitarian parole. A lot of Afghans who entered the U.S. entered with humanitarian parole. We saw that with the OAW or OAR, so Operations Allied Welcome or Operation Allied Refuge. So those were considered humanitarian parole entries. So humanitarian parole grants are pursuant to INA 212D5, and then they're considered humanitarian parolees. And so this is a common grant of parole for those who present at a port of entry, and then they're designated as arriving aliens on the NTA. So those are considered humanitarian parolees. And then we have conditional parolees. So Afghans who entered or tried to enter the US without inspection, and who were detained at the border for any amount of time, and then are subsequently released on an order of release on recognizance. And this is pursuant to INA 236A2B. These people are considered conditional parolees. And so on their NTA, the second box at the top is going to be generally marked, and that is alien present in the US without being admitted or paroled. So that would be kind of what it's marked on the NTA if the person did enter with conditional parole after trying to enter without inspection. So both groups of people who were granted humanitarian parole and those released on an order of recognizance, are going to be likely issued notices to appear, and then they're placed in immigration proceedings. And then just a note on matter of Cabrera Hernandez. This was a very recent BIA case. I believe it was June of 2020 or July of 2023. And so the BIA did hold that release on conditional parole under INA 236A2B is legally distinct from humanitarian parole, and that conditional parolees have not actually been inspected or admitted. And so this was in the context of a Cuban Adjustment Act case, and they found that this person is not eligible to adjust status if they were released on their own recognizance or conditionally paroled. Okay, so just to take a look a little bit more in depth at humanitarian parole, the documents you'll be issued if you're granted humanitarian parole include an I-94, and that's our arrival departure record. And that could be endorsed with a parole stamp. Also an interim notice authorizing parole. We're seeing Afghans being issued those. This still counts as humanitarian parole, but it doesn't come with the I-94. They can also have a parole stamp in their passport. So these are all types of things that can show that they were granted 212D5 parole. Their I-94 for a lot of our Afghan clients may also refer to a class of admission like OAR or OAW, or just DT, which is the code for those granted humanitarian parole, or otherwise known as port parole. So all of these, if they have an I-94 that shows any class of admission under 212D5, these people have humanitarian parole. If the person didn't actually receive an I-94 or somehow lost it, again, you can check for the electronic I-94 on the CBP website, or they can also check on the CBP-1 mobile app. And so for humanitarian parole, it typically lasts 2 years. So a lot of people, Afghan entrants, we saw that their parole expired last month. So that's where the re-parole process came in, that was implemented in June to extend this initial period of 2 years of parole. Otherwise, if people who were granted humanitarian parole but were not under OAR or OAW, or just under 212D5, they may have been granted, maybe 6 months or 1 year of parole. So the parole duration period can vary. So let's take a look at the legal implications of humanitarian parole. So this would be considered an inspected and admitted or paroled. This is a true parole according to the BIA and DHS. Certain Afghan parolees are authorized to work incident to this parole status, but only for a period of 90 days. They have to present their unexpired I-94 as well as for the first 90 days. And then after that, they would need additional documentation such as an EAD or unrestricted social security card. But that's the benefit of humanitarian parole, is that they are authorized to work incident parole. This is temporary in nature. So this in itself does not lead to any permanent benefit. So that's why USCIS, with the implementation of the re-parole process, was encouraging everyone to apply for a permanent benefit if they have not already, such as asylum or adjustment of status. It's important to note too that Afghans who entered with humanitarian parole are eligible for ORR benefits, and that is even if the code on their I-94 is not OAR or OAW. Okay, now we're going to take a quick look at conditional parole. So when someone comes to you and they have an I-220A or order of release on recognizance, you can pretty much assume that they were not granted humanitarian parole and were actually given conditional parole or just ordered released on their own recognizance after being detained. This is a sample of that I-220A. These do not show an expiration date. It's generally just pending, removal proceedings. Many people who get these or are released from detention and newly arrived in the US get confused and think that they were actually paroled and eligible for, work authorization or OR benefits being from Afghanistan, but unfortunately they're not. So generally, it's unlimited in duration, but they are being released pursuant to pending removal proceedings. Okay, and then some of the legal implications of conditional parole. We know that this was not an inspection and admission, and people are not, so they're not truly considered paroled in the US like their humanitarian parolee counterparts. And then conditional parolees, the word conditional comes from a certain set of conditions they have to follow that's going to be in that order of release on recognizance. They have to sign and agree that they're going to report to any interview or hearing required by DHS or the court. They have to attend their check-ins with ICE as outlined on the I-220A, and they always have to make sure that they secure permission to change residence before they move from DHS. And so these people are typically issued NTAs, placed in removal proceedings, and so they have to file, their application for asylum defensively. And unlike humanitarian parole, they're not granted work authorization. So hopefully, they have a pending asylum application or other application at this point, or a granted TPS with the expansion of TPS eligibility, so they can secure an EAD that way. And these people are also not eligible for OR benefits, as they would have been if they were granted humanitarian parole. Okay, so with that, I'm going to turn it over to Liz to discuss the asylum processing rule.
Sorry, everyone, is on mute. So we wanted to shift gears a little bit to talk about some recent regulations that have gone into effect in 2022 and 2023 that impacts those who are seeking asylum, who are entering along the southwest border. This first one that we're going to just briefly touch on was a regulation that went into effect in May 2022. Up until now has been relatively limited in scope. Basically, it was first rolled out as part of a pilot program that detained single adults in certain detention facilities who announced an intention to live in certain cities were being referred to this, what they call this asylum merits interview process after receiving a positive credible fear determination. And at this time, that as of this month, actually, new referrals will also include certain non-detained families who meet other parameters. And so the basic sort of structure of this rule is that typically, oftentimes an asylum seeker who expresses a fear of return will have a credible fear interview and then will be referred to removal proceedings. What this new rule changes is it sort of puts in this intermediate step that someone who passes a credible fear interview will then go to have what they call an asylum merits interview that looks a lot like an affirmative asylum interview. It's before an asylum officer. And the difference being here that the USCIS officer actually has jurisdiction to grant asylum or to, if they don't grant it, to refer to court for streamlined removal proceedings. And when they say streamlined, essentially meaning that the proceedings are to be completed within a very sort of tight timeline. I believe it's 135 days once proceedings are initiated. And again, this went into effect in May 2022. It's really been rolled out slowly. It's limited in scope. It only applies to those who entered after the effective date of the rule, but even then, a lot of folks have not been placed into this program, but certainly has the potential to in the future. So we just sort of wanted to make you aware of this possibility. If you see clients getting notice that they have something called an asylum merits interview, that is sort of the process that they're going to go through. And then the other regulation that certainly does have the impact, potential to impact a lot of folks who are entering more recently is this it's called the Circumvention of Lawful Pathways Regulation that went into effect on May 11th, 2023, applies to those entering on or after that date. The rule is supposed to only last for 24 months, but we'll see about that. And so basically, the rule creates a presumption of asylum ineligibility for those who are crossing at the southern border, adjacent coastal borders. It does not apply to those who avail themselves of an existing lawful process, like the Cuban, Haitian, Nicaraguan, Venezuelan parole program, obviously not applicable to this population. Doesn't apply to someone who presents at a port of entry, basically who makes an appointment using the CBP-1 app, or if they present without an appointment and they can establish their inability to use the app. Doesn't apply to a person who has been denied asylum in a third country. But basically, this rule is sort of intended to, again, create this presumption of asylum ineligibility for folks who are, perhaps trying to enter the U.S. Without inspection, again, on or after May 11th, 2023. So again, creates this rebuttable presumption of ineligibility for asylum. And to rebut that presumption of ineligibility, the person has to show an exceptionally compelling circumstance, including an acute medical emergency, an extreme threat to their life or safety, or being the victim of a severe form of trafficking. So again, the point of this rule is to incentivize people to make appointments via the CBP-1 app rather than presenting without an appointment or entering without inspection. But we all know the practical difficulties of, how hard it is to actually use that CBP-1 app. The appointments are very limited. So again, because this rule is relatively new, it hasn't necessarily affected a lot of folks so far, but we certainly expect it will in the future. And Mona, I don't know if you can speak if you've had experience with this, with the Circumvention of Lawful Pathways rule or the AMI process for Afghans, or if you know of any cases sort of coming down the, that you expect to see in the future.
Yeah, thanks, Liz. So we haven't had any go through the entire process just yet at HRF, but I have spoken with others who have had some of these cases, and of course, given the time frame, we will start to be, see this more frequently, since anyone who's coming in now will be potentially subject to this rule. So I think just, as you described it, making sure to really outline the exemptions, the particular vulnerability of the client, the particular language barriers. I think, there's advocacy papers that have been put out regarding just the inability of CBP-1 to recognize certain skin tones, and so there's lots of ways to sort of argue against this. I'm hearing, from others I've spoken with that DHS is just, automatically, raising this in removal proceedings, and they expect for it to bar the clients, and that hasn't always been successful. So I think, there's space to argue against it, and we'll just see, in cases moving forward, how they go.
Great, thank you for that perspective. And I think we're going to turn it over for some audience participation polls in terms of what folks are seeing.
Hi, everyone. I'm Rebecca here. So we would love to hear from you all, the audience, about what you've been seeing in your practice, especially those who are located closer to the southern border. So the first poll question, and I think, Liz, you're going to run the poll, is from what you see in your practice, are most Afghan clients or Afghans in general arriving at the southern border receiving this special 212 D5 humanitarian parole? If you can please respond yes or no. And if you don't have any insight into this, you don't need to participate. So we'll wait to kind of see how people respond.
Sorry, Rebecca. I think the questions were out of order. So folks are actually answering first the question, are most Afghans using the CBP One app? I'll try to get back on track for the next one. I think I clicked.
All
the
right,
wrong-
well, let's go with
But
that
just
one.
so you know, just so you know what we're getting an answer to.
Are most folks using the CBP One app and entering at a designated port of entry? I know what we see from a lot of our affiliates and the people they talk to is the wait is months. So a lot of them get really frustrated and decide to try to enter without it. So I'd love to see what their response is. We are running this poll, right?
Yes, I'm going to share the results right
Got
now. It. There we go. You see it?
Okay. No.
Oh,
Yeah, that's kind of, well, I mean, a lot, yes, no. And you can also put in the chat about the wait times that you're hearing. I just look at the data online from our government and then you see a lot of articles. But if you can add any experiences that you know of in the chat, that would be really helpful for us all to learn. And so I don't get out of order. What's the second poll question?
Let me pull it up. So I'm gonna run the poll that says, okay, are most Afghans receiving 212 D5 humanitarian parole?
Okay,
Let's
wonderful.
that
So
one.
back to the first question. Yes, are any of you seeing Afghans that are receiving this 212 D5 parole more recently? That would be good for us to know.
All right, we are getting some participation. I'm just going to give it a couple more seconds and then share the results.
And we got an interesting comment in the chat from Alicia. I do most of the Afghan cases for our state of Nebraska and haven't seen any come in through the border yet at all. I know where I used to work in Charlotte Immigration Court, they have seen a few Afghans. It seems like the ones, the report I get, have not received that 212 D5 parole recently. So what we're seeing is no. 46% yes, 54% no. Okay. And if you have any other comments to add to the chat, that'd be wonderful. And then we have one more poll. For those that are seeing some type of parole, what kind of parole? 212 D5 at least a year, because I know it can sometimes be more. It can be up to 2 years, or you see in more interim short-term parole, less than a year. You can, and then other. If there's some other weird parole status you're seeing, please add to the chat. Let's see here. You're seeing here we get a lot of 1 in the chat. No parole. 2 months DT parole to be determined. The mix up. So let's see what the poll says. Okay, it looks like we got 61% are seeing at least a year parole, where that's good. And then we're seeing some parole, about 15% less, and then other, which seems like that just leaves out a lot of people with no parole at 24%. So thank you for participating. And we do have one more question, and this is just for the chat. If you can just describe in the chat some of the main travel routes you're seeing that Afghans are taking to arrive at the border. One of the most common that I've seen, and then I think someone also concluded in the chat, is getting a visa to enter Brazil and then going through all the different countries, the Darien Gap sometimes, which is very dangerous, and making their way to the border. That's what, okay, Iran first, Brazil. Yeah, flying to Brazil. Seems like Brazil's the hot spot. We're seeing a lot of Brazil, so it's kind of confirming some of the trends that we're seeing. Okay, thank you for participating.
Yeah, that's really interesting. All right, so this is just to kind of give you a sense. This is sort of the increase in Afghans in removal proceedings, gone up to more than 5,000 this year from 610 last year. So nearly 9 times the previous year. It's still a small percentage of overall cases in removal, less than 1%, but there is a big kind of, overall increase in the number of cases of Afghans in proceedings. One of the things that we just wanted to talk about as we, transition into more of the merits of representing someone, in their case in immigration court is what are removal proceedings and what happens in immigration court. And I'm sure we have lots of, a range of expertise here, maybe from very experienced attorneys or representatives to folks who don't practice in immigration court at all. So bear with me as I give kind of a broad overview of that procedure. But basically, removal proceedings are hearings that take place in immigration court to determine whether a non-citizen should be removed or deported from, when we say removed, essentially deported from the United States. And basically the hearings are sort of in 2 phases. There's the removability determination. So once someone is placed in removal proceedings before the judge, the first step is for the judge to determine whether or not the person is in fact removable. So, are they inadmissible or they're deportable as charged in their notice to appear. Many of the Afghans that we're seeing are going to be charged with inadmissibility, either because they entered without inspection or because they didn't have a valid entry document to enter the United States. And so once that threshold question of removability is established, then we get on to the relief stage. So the judge will turn to whether the non-citizen is eligible for any type of relief from removal. In terms of who's who in immigration court, this is an adversarial proceeding. So there is the respondent, the non-citizen, who is the person in removal proceedings. There is the respondent's attorney or fully accredited representative. The government is represented by an attorney from Immigration and Customs Enforcement, Office of the Principal Legal Advisor, which is a sub-agency of Department of Homeland Security, DHS. So you'll often see the government attorney referred to as Assistant Chief Counsel or a trial attorney. And then we have an immigration judge who is presiding over the proceedings. The judge is an employee of the Executive Office for Immigration Review, which is part of the Department of Justice. And then, other players you may see would be, the interpreter. It could be an employee of the court. Most likely it's, someone contracted with the court. A lot of interpreters are now appearing virtually as well. And the immigration judge's clerk or legal assistant. And again, this is set up like an adversarial system. So it's a trial, where both sides can present evidence. We have examination of witnesses, and then closing arguments, right? So you'll have, typically your main witness in your case is the non-citizen in proceedings. So you as the attorney or representative would, conduct that direct examination. ICE has the opportunity to cross-examine the witness. And you can also, of course, present other witnesses, including expert witnesses like a country conditions expert or, someone like a medical evaluator or someone who's conducted a psychological evaluation of your client. So the document that starts removal proceedings is this document called a notice to appear, and removal proceedings don't start until DHS issues a notice to appear, serves it on your client and on the immigration court, right? So them simply serving your client isn't sufficient for the proceedings to start. They have to actually serve it on the immigration court. And typically you'll see these 3 boxes at the top. The 3 categories are someone who's considered an arriving alien. Usually that's someone who's presenting at a port of entry, someone who is present in the US without having been admitted or paroled. Those are folks who are usually entered without inspection. And then folks who are admitted but deportable from the United States. The notice to appear also contains specific factual allegations. So they'll outline the specific facts or conduct that make the non-citizen removable from the United States. So essentially, what immigration law have they actually violated? and then the underlying legal charge, right? So if you're saying, you know, that you entered without inspection on this date, the legal charge is going to be 212A6A1 for having entered without inspection. And then the notice to appear also contains other important information, including, which has been, you know, repeatedly affirmed by Supreme Court and federal courts, that the notice to appear, in order to be a valid document, has to have the date, time, and place of the hearing, giving the respondent notice of when they need to appear in immigration court and where. And the basic sort of sequence of events in immigration court is that you might have something first called a master calendar hearing. And so those are typically sort of short preliminary hearings where you might, you know, present the pleadings in the case, you know, respond to the allegations and the charge in the notice to appear. You might submit your applications to the court. The immigration judge may do a status check on the case, and then you can also use it for the purpose of scheduling that individual hearing on the merits. Some courts are now moving to a system, especially where the respondent is represented, where they're issuing what's called the scheduling order. So they'll ask for written pleadings rather than scheduling a master calendar hearing. And then once those written pleadings and the application for relief are submitted, then we would move on to that individual merits hearing. And again, that's where we have this sort of trial-like setting where we're presenting evidence, DHS is cross-examining our witness, and ultimately the immigration judge is going to make a decision on the application. And then finally, we have the appeal stage if necessary. So either side can actually appeal. If the immigration judge grants relief, then DHS can appeal. If the immigration judge denies relief, then the respondent can appeal. You do want to reserve your right to appeal at the end of the hearing. Otherwise, that right to appeal is going to be waived. And then there is a 30-day window for filing that notice of appeal with the Board of Immigration Appeals. And then after that notice of appeal is filed, they will later send out a briefing schedule and a transcript of the proceedings. So that's kind of, you know, again, our high-level overview of immigration court. But I would like to turn it over to Mona at this point to really talk about her specific experiences, especially representing Afghans in detention, or not just in removal proceedings, but also detained.
Thanks so much, Liz, and everyone. I'm very happy to be here. I don't have control of the PowerPoint, so I would just say you can move on to the next slide. Thanks. So I'll just start with just some, you know, basic information about detained representation, and then I'll conclude by sharing one particularly egregious case that I've been working on over the last 5 months. So generally, some things to remember about representing immigrants in detention settings. So these proceedings will move at a lot faster pace than your removal proceedings for non-detained cases. Those cases can take several years, you know, potentially to get to a merits, unless you have a client who's on a, you know, rocket docket or something. But detained cases will go more quickly. Judges are mindful that you know, detention should not be prolonged. For the most part, that doesn't always happen in practice, but they do move more quickly. Often individuals who are unable to secure counsel will have to go forward pro se, so they can ask for continuances only a certain number of times before the judge says you've just got to go ahead. And unfortunately, you know, many organizations are really backlogged, and it's not very common that detained immigrants actually do have representation. When they are represented by counsel, however, they're approximately 10 times more likely to win relief and almost 7 times more likely to be released from custody. So if you have detained immigrants who do not have representation, they are much more likely to be detained really prolongedly. And this is not good for them, not good for our human rights record, and certainly not good for, you know, the public interest in terms of taxpayer dollars and all of this. And yet it continues to happen that way. Detained immigrants face a lot of barriers to access to counsel, even when they do have an attorney. So you'll find that pro bono attorneys or just attorneys who are working with detained clients, they have a great deal of difficulty speaking with their clients when needed. So often phone access is very limited. Even if you're able to get your client on the phone, oftentimes there's, it's scratchy or it's very difficult to hear. There's a lot of background noise, very poor audio settings. Oftentimes it's very difficult to make appointments to speak with your client. So you might call to make an appointment, or you might call and ask your client to call you back, and that message will not be delivered. You also have circumstances where there's really a lack of confidentiality for immigrants who are detained. So you may be able to go in person and meet in contact settings. That stopped for a while during COVID. But it should be, allowed in certain settings, not all settings now. But in those circumstances, you're in a room and you're by yourselves. But sometimes you are speaking to your client through a glass wall or glass window with the telephone, and it's very difficult to hear. And you have, deportation officers walking around. There's also no real guarantee that you can have phone calls that are not monitored by ICE. So these are just some of the difficulties that immigrants and barriers that immigrants face when they are pursuing asylum or any kind of relief while detained. Often, obviously for Afghan clients, you may need interpretation, and so sort of collaborating with a third-party interpreter is not always easy. I don't mean to dissuade anyone from taking detained cases, because as you can see, it's very necessary, and people really do need the assistance, but these are some of the issues. Deportation officers are also notoriously difficult to reach. They don't give out phone numbers often, they don't give out emails often, and they often don't call you back. So you can go on to the next slide. So just some first steps I would suggest is, if you do end up taking a detained case, really immediately file your G28 with the detention facility and register your phone number so that your client can call you. Sometimes your client will have to pay to call, and this is just outrageous, as you can imagine. But if you register your phone number, in some instances, hopefully in most instances, they can call for free. Again, that doesn't always happen, but it makes it easier. I would, try to obtain copies of your client's documents as soon as possible. It's really, as I mentioned, it's really hard to interact with your client just as needed. So if you can get all of the information that they happen to have from the beginning, that's helpful, so you can work through what you need to. Obviously, the NTA, if they have the I-213, which is a document that shows additional information about the actual arrest or the encounter between CBP and your client, it's really important that you go over these documents with your client carefully so that you know that they're accurate. If they aren't accurate, certainly before doing pleadings in court, if they aren't accurate and you're doing pleadings and you're conceding to things, that may be problematic for your client. If you can get the CFI worksheet just to see sort of what the information is that was already disclosed to the government, so that you can ensure that your future applications are really consistent for credibility purposes, or you can make corrections where needed. Find out if they were given a bond amount, any applications that were filed, etc. Try to establish contact with the DO. Your client will typically know who their deportation officer is, but you can also potentially find that out from the front desk. And just try and make that contact as soon as you can. They do change, with some regularity, so just keep that in mind. And then I would also submit a FOIA request. Just going back to the Afghan cases, FOIAs are really important. If your client might have conviction records, you really need to know what is the history and what kind of information might come up in the context of your merits. So that may or may not be as relevant for Afghans who have not lived in the United States for a very long time, but generally, always recommend doing that. And then when you're thinking about your client trying to obtain permission to be released from detention, there's various ways you can pursue that. Bond hearings, you can pursue bond under section 236A, which is a discretionary bond that you kind of prepare a bond packet, you request from the IJ to have a bond hearing. They will typically do that within 10 days. you would need to, submit a declaration from your client that, shows that they're not a danger to the community and that they're not a flight risk, and get supporting documents and evidence from their sponsor if they have one. So ideally a sponsor who has some kind of status in the United States. And then you want to include things like their tax returns and, just a full fleshed out release plan to the extent that you can before you submit your request, so that once the hearing is set, you're ready to go, and then prep your client for giving testimony. The Afghan cases will most likely not have to deal with mandatory detention, but in some instances, bond is not immediately possible. Again, that will likely not be the case for clients. You can submit parole requests. So this is another way to request release from detention. You go through ICE, prepare a similar packet. This has worked in the past. We have seen instances where this has worked. I have tried for this particular client that I will share about momentarily, many times to get him released via parole requests, and it has not been successful. But again, that's a means that you can utilize. And then of course the alternative detention. Sometimes it's helpful in the bond context to talk with your client in advance if they are amenable to having an ankle monitor. It's a very difficult thing to have, but sometimes it helps get get the IJ over the edge to allow reasonable bond. And just to make a point that bond, the minimum bond amount is $1,500, depending on the IJ, depending on the jurisdiction, depending on their particular personality, that may go up, and depending, of course, on your client's facts and if there are convictions, et cetera, that may go much higher. You can get $20,000 bonds for people you would really never, it's just shocking and egregious. And of course, even for some detainees, even $1,500 is impossible, but these are sort of the ranges that you might find. And so I would also just suggest, if you are going that route, contact bond funds. There are bond funds throughout the country and potentially in your state where they help fundraise for your clients, and may already have money that they can contribute towards paying that bond for a particularly, for a sympathetic case. And there are organizations like Miles for Migrants, which use people's airline miles to help book flights. So if you have a client who is detained one state, their sponsor is in a totally different state, they need to be responsible for paying for that travel. But again, oftentimes this is very, bond is prohibitive with the fees that are involved. So organizations like Miles for Migrants can potentially help with booking flights. And then, you can, just for Afghan cases in particular, it's helpful to include as many letters of support from the sponsor and others attesting to the good nature and sort of the various equities of your detained client. But you can also reach out to Afghan specific organizations to get a letter from them. We've reached out to Project Anar and Afghan American Community Organization in the past to bolster the parole request or the bond request and show that the Afghan person has really a safety net where they have the community will be really helping to keep them stable and making sure that they have a way to get to their hearings as needed and to the ICE check-ins as needed. So just some trends in Afghan detained cases. We talked about this earlier, most Afghans are coming through the southwest border of the United States through Mexico, and they're traveling through Brazil. There is, as we kind of determined earlier, there's really no consistency on the parole. It seemed like half of this group has seen parole, for border crossing, and half has not. So there's really no clarity on when and why that happens. This is unrelated to detained cases, but we're also noticing an increase in Afghans who are crossing the border who actually have SIV or are SIV eligible, but they just, for whatever reason, they should have they should have been assisted to evacuate earlier from Afghanistan, and because the whole system just was so chaotic and there are such backlogs, they were not. And so oops, if you can just go ahead. And so we're seeing those people who are just saying that, it's too dangerous and they can no longer wait in Afghanistan. And so they're coming through this treacherous journey through multiple countries, either through Pakistan or Iran, and then going through, Brazil, and then through the Darien Gap. And, we're really hearing just really horrific stories of the dangers that people are facing in order to get here. And then, of course, as Liz mentioned earlier, the lawful pathways, circumvention of lawful pathways applies. So just make sure to remember that if your client has crossed the border after May, early May 2023, and prepare arguments around why they couldn't use the CBP1 app, and that there was no third safe country. There's a question in the chat about visas for Brazil. So, people are able to get visas to Brazil, and just something to consider about Brazil is that actually Brazilian authorities are apparently, at least in some cases, providing Dari interpretation in the airport to let people know that they are potentially eligible for humanitarian residency or some kind of residency in Brazil. So this is something that is coming up in cases as we, continue to hear these cases, whether they're in the affirmative or in the removal context. And you just have to kind of be prepared to make firm resettlement arguments. And that will really depend on the jurisdiction and the circuit that you're in, exactly what those firm resettlement arguments would be. But typically it's, really relates to if you're offered a permanent residency, in some circuits, they talk about, but for one ministerial step that you would have had that permanent residency. If it's a temporary status, which we're seeing that it is in Brazil, it is a humanitarian status, but it's temporary. If that's the case, that is not a permanent residency offer, and so firm resettlement should not apply. So just some things to kind of think about as you think through your cases. Other trends are that, mostly men are being detained, what we're seeing, even when they enter with a family. Oftentimes single men are detained, single young men are detained, 20s to 30s or so, but also hearing about men who are separated from their families, the wife and children are released. I've also heard of cases where, individual enters in Calexico and then is detained somewhere in the Fifth Circuit, and then the family is, in a third state altogether. So it's really not the most efficient, way to handle these cases. I don't know what the reasoning is on, why they send someone where they do, but those are just some trends that we're seeing. Also hearing that immigration judges are and experiencing that immigration judges are very, very unfamiliar with Afghanistan country conditions. You would think that anyone would know just the utter dismay and chaos and violence and danger that anyone in Afghanistan who doesn't follow the Taliban's rule would face today. But unfortunately, we're seeing that judges are really not looking at the circumstances today, and they're really unfamiliar with a lot of the nuances of Afghan cases. So for example, you have many Afghans don't have birth certificates. They have tazkiras, they don't have birth certificates. Sometimes the tazkira, which is a form of identity document, is very old, it's on paper, it doesn't seem legitimate. And immigration judges are just not necessarily that familiar. And, we were sort of promised that asylum officers are getting trained about Afghanistan, but judges are not necessarily getting that same training. So it's really important to just really bolster your client's case, especially in the detained context where it goes much quicker. Bolster your client's case, bolster the country conditions, get a country conditions expert declaration if you can, have them testify. A lot of detained judges are, more difficult So you really want to make sure that you have the information that's needed. We're also hearing, I heard someone told me that the IJ was acting like a prosecutor in her case. And of course, we've all, had those kinds of experiences where, you're really shocked by the way that the questioning goes and by the, just by the handling of the case. And so I would really encourage folks, if you are in a circumstance like that where your client is detained and the judge is really not allowing you to take testimony, or is really just opining politically, or is, in whatever way is, foreclosing your client's opportunity to speak when needed. Object when you need to. Make it very clear what the issues are on the record. Say, Your Honor, I just want to be clear for the record, X, Y, and Z. So if Your Honor would have allowed my client to, give this testimony, he or she would have been able to speak to X, Y, and Z, or it's really important for my client to establish her credibility by talking about these issues, and just really make it clear for the record so that you have those issues on appeal. And then, detained hearings are very often held via video. So if you have detained clients, if you can go in person to meet with them, please do that. It's important for them to get to know you, to build trust with your client. But, oftentimes the judge will be in a completely different court. And your client will be, not all detention facilities have their own courts. So Adelanto in California does, but not all detention facilities do. So, there's going to be some of that to maneuver. So it's really important to establish a good relationship with your client in advance so that you can at least remove some of these difficult, barriers, and so that they really trust you and you trust them, that you have the information that you need, and just, employ cultural sensitivity. Just remember that, Afghans are not monoliths. They speak multiple languages. They are multiple ethnicities. They have multiple religions. And, it's just really important to get to know your client and be respectful of the potential differences in culture. And of course, your detained clients are going through not only the trauma that they faced in Afghanistan that led them to flee, whether that's actual attacks, threats, family that have, lost their lives and suffered torture, but then the added trauma of that travel through, all of these countries in order to get to the United States where they thought that they could be protected. And then the ongoing trauma of continuing to be detained and treated, as some say, treated like a criminal, and no judgment on, crimes, because the criminal justice system itself has a lot of problems, but just those are kind of the sentiments that Afghans sometimes convey, their shock at the treatment. And then just a final note, TPS should lead to release from detention if you're facially eligible. That doesn't always happen in practice. And cases that are entering without inspection, for prosecutorial discretion, they are being considered border security threats, and prosecutorial discretion is not being employed. So I'll just wrap up quickly with the next slide, just to give you this example of one of my clients that, as I said, just this really egregious example of treatment for an Afghan who came to the United States in 2022, survived multiple, survived a suicide bombing as a Hazara, and personalized attack by the Taliban, was shot at, and was forced to pursue his asylum proceedings per se. He was prosecuted under this 19 USC 1459, which pertains to, this unlawful entry and failure to present at the border. This is something that, if you haven't heard about it, a lot of Afghans have been subjected to this over the past year. In the Western District in Texas, there was sort of one region that was employing this. What ended up happening is, mostly Muslim immigrants from Muslim majority countries were being impacted by this. And it was causing them, and including this individual, to be detained in, prison for 7 months or so, before actually being transferred into ICE custody, where then for the first time they could seek protection of the United States. in terms of asylum. And it's, it's just outrageous, obviously. This was reported in the LA Times, and I've included links here if you're interested to read about it. There are a couple of articles in the LA Times. Mohammed is mentioned in one of them. And DHS has now announced that they will be doing investigation on this. So that's good news. They are no longer doing this 1459 prosecution, but they are doing the 1325. So it's not entirely gone. And so Mohammed has been detained now for a year and a half or more. He was forced to move forward pro se because none of the organizations that he reached out to could represent him. He thought that, he could represent himself. He provided a lot of evidence regarding his Hazara ethnicity and other minority statuses and potential PSG formulations. The IJ in Texas completely railroaded the hearing, basically argued that he should have died in order to prove past persecution, didn't accept, said, well, you weren't shot by the gun that was pointed at you, and you survived the suicide bombing, and your, wife is still there. And that shows that you are safe to return, that you haven't met your burden. And this is just, completely shocking and dismaying. And then, what made matters worse is that then on appeal, unfortunately, he was not given proper instructions regarding the need to affirmatively protect his right to appeal. And so the BIA argued that, and the government argued that he waived his right to appeal. Of course, we argued that, that was not knowing and intelligent, and reading through the transcript, it absolutely was not proper instruction by the IJ, but unfortunately the BIA dismissed for lack of jurisdiction. And so, this case then went up to a petition for review at the Fifth Circuit. That was ultimately voluntarily dismissed, because at the same time I also filed a motion to reopen with the judge. And then many supplements later, including lots of changed evidence, arguments for changed country conditions in the country, additional pathways for relief. This case was transferred from one judge to another, and that judge granted the motion to reopen. Really great news that happened on the very same day that TPS was announced for Afghanistan, the redesignation. So it was lots of great news all at once. Unfortunately, this individual is still detained. Despite having many equities, despite having a spouse who worked for, was associated with the US government, worked for the former Afghan government, etc. So there's some press here about that. There's a campaign to sort of argue for his release. If you'd like to sign on, that link is at the bottom. And this is just one example of just really the inconsistent treatment of Afghans in removal proceedings. And a bond hearing. So a bond hearing was not possible throughout the time that he had a final removal order. So while he was on appeal, I was arguing that ICE should release him for, through parole requests. And unfortunately, DHS was not amenable to that at any stage, many filings. But you're not actually eligible for bond while you're, well, he was not eligible for bond at that point. He now has a motion to reopen granted. He no longer has a removal order, a final removal order. So he is now eligible for bond. This is where my representation ends. And now that the NTR is granted, we'll be transferring the case to an external pro bono attorney. And so I'm advising that they do bond, and we'll see where it goes.
Thank you, Mona. I just want to say that was so insightful. We're so glad Mohammed has had you advocating for him for these past couple months. Probably without any of that, none of this would have been possible, and he would have never got that motion to reopen granted. And thank goodness he got a different judge. Maybe that was the key that helped as well, aside from your advocacy. And I know a lot on the call today, learned a lot, and might have follow-up questions for you later. But moving on, because a lot of what Mona said kind of ties into what I'm going to talk about, and Liz is going to share a little bit about some of the bars to asylum and TPS, but we are going to focus on two pretty prominent forms of relief for Afghans. Of course, there's others, especially SIV, and there's still a lot of family-based eligibility for Afghans, but our focus today for Afghans who are, for the most part, non-detained in removal, but it also applies to those who are detained, is TPS and asylum. And I assume that many on the call today are pretty familiar with TPS, so I'll just go over it very briefly. But essentially, DA Secretary of Homeland Security and the Secretary of State designate periodically certain countries that are dealing with a form of civil strife or an environmental disaster. Think about Afghanistan and all that's gone on, to have for individuals in the United States, for those citizens or nationals of those countries, to have what's called temporary protected status. And again, it's temporary, hence the image on the slide, and does not lead to permanent status. But it can be really important, especially to help preserve people's ability to remain in the country, to have a work permit. And sometimes they can also request permission to travel abroad and re-enter the country with advanced parole. So Afghanistan is a designated country for temporary protected status. And its first designation was from March 20th, 2022. And that was for folks who had been residing in the United States as of March 15th, 2022. And that was very exciting times that we had TPX for many of the folks that came in the first wave of Afghans around August, September of 2021, with that special OAW status that could qualify as well for TPS, as well as any other eligibility they might qualify for. But it started to leave out a lot of Afghans as they came in after that special date, especially affecting folks coming in from the southern border and seeking relief in the United States. So fortunately, as Mona mentioned, in September of this year, September 20th to be exact, those non-citizens from Afghanistan who were in the country as of that date, September 20th, 2023, can also apply for TPS if they're eligible. So essentially, it was Afghanistan was redesignated a country for TPS. And they must prove that they've resided in the country since September 20th of this year and have continuous physical presence since November 21st of this year. And just briefly, because I know a lot on the presentation today are aware of TPS, they must prove that they haven't been convicted of any felony or 2 or more misdemeanors that were committed in the United States. And if they are found inadmissible, there is a waiver, the form I-601, that waives many grounds of inadmissibility, not all, but the mandatory bars to asylum under INA 208 B2A do apply to people applying for TPS. And Liz is going to talk about a couple of those in a little bit. One of those bars that she's not going to touch on, that Mona did touch on, is the firm resettlement bar. So that also applies to folks who are seeking temporary protected status. And it does come up, as Mona mentioned, in the Afghan context. Clinic has a great advisory in conjunction with the ABA and some other organizations. I think Liz might refer to this as well. I'll share the link with everyone in the chat when I'm able. It's a really good practice advisory for representing Afghans in general, in removal or not, that I encourage all of you to read. So the dates are important for applying to re-register or applying for the first time. So let's just go over them very briefly. If an Afghan client currently has TPS under the initial designation period and would like to keep their TPS, which many of them do who have not yet been granted permanent status, they must re-register by filing their application affirmatively with USCIS during the 60-day re-registration period. So it's not very much time. It started September 25th of 2023, and they have until November 24th of this year to resubmit to re-register for TPS essentially. So make sure you get that in for folks who want to re-register. For those who are filing initial application for TPS, they need to register between September 25th, and they have a much longer time frame that they can register by May 20th of 2025. So go ahead and get those applications in for folks applying for the very first time. And I've seen this question a lot. I'm on the wonderful Paula calls every Friday. So what if someone's applied initially, but is still pending? Well, USCIS has confirmed that they will go ahead and extend those folks' TPS through the May 20th, 2025 period. So they don't need to reapply. But for people who just applied and got an approval shortly before this redesignation, they still need to go ahead and re-register. So that can be a bit annoying, but necessary. And if you have any questions about that, just include them, in the Q&A. So you can go on to the next slide, Liz. And briefly as well, because asylum is quite a complex area of the law, and despite this rebuttable presumption, and a lot of the everyone who's entering at the southern border since May of this year, to have this extra layer of what they need to prove to be able to seek asylum, just bring it back to the basics. Any Afghan seeking asylum must meet the definition of a refugee. And I just included the definition of a refugee on the screen there. Essentially, they have suffered past persecution or have a well-founded fear of future persecution on account of their race, religion, nationality, membership in a particular social group, or political opinion, and their government is unable or unwilling to protect them. An asylee essentially must meet the definition of a refugee, but actually be physically present in the United States or at a port of entry. And I can tell in the chat that a lot of you have done a lot of affirmative asylum filings with USCIS, so you have a good understanding of asylum law, especially in the Afghan context, which is wonderful. But do remember, especially in immigration court, it is so particular. Each word has been litigated in federal court by the BIA. There's, depends on where you live, which circuit, and as Mona mentioned, which judge. Is kind of like, there's a wonderful book called Refugee Roulette. It's the roll of the dice sometime, depending on if your judge is going to grant you asylum or not, or if you have representation in court or not, or like Mona mentioned in this case with her client, if you're detained or not, because that has an effect on access to counsel, and also the ability of the judge to interact with you, because it's always on video, to hopefully grant you asylum and assess your credibility. So if you just go on to the next slide, just a little flow chart, because again, we can't get into the weeds of asylum today, but this is just a brief diagram to remind you of the elements of asylum for all Afghans seeking asylum, just like any asylum seeker, that they must meet. And one caveat is they cannot be subject to any bars to asylum, which not in just the Afghan context, in any of your clients who are applying for asylum, you should screen for any potential bars. But I've represented many Afghans and continue to represent them. And I do know it comes up a lot in the Afghan context. So that's why Liz, in the next few slides, is going to delve into a couple of the bars, so you have a general overview of what to look for.
Thank you, Rebecca. So, Rebecca has mentioned the mandatory bars to asylum also apply to TPS. So you really want to be thinking about these bars, whether you're applying for asylum for your client or for TPS. And I would say, I've seen already people in the chat kind of asking questions about the firm resettlement bar, about the persecutor bar, about the trig bars, because I think, because of sort of the way these cases have unfolded, the history of conflict in Afghanistan, the designation of the Taliban as a terrorist group, and then the sort of new issue with the issue of the visas being issued by Brazil. There's potential for, implication of one or more bars in a lot of these asylum cases, which make them, much more complicated. And again, we don't really have time today to go into the weeds on, these bars. But what I did just sort of want to emphasize was one, pointing you to a resource that is available on our website, written in conjunction with ABA and other practitioners about navigating the bars to asylum. So we do go into a lot of detail on firm resettlement, serious non-political crime, persecutor bar, and the trig bars. And there's some really helpful appendices that I think you can be useful as you're, preparing your client for testimony. So kind of going through questions that your client can be expected to be asked, for example, about their history of military service, and sort of, determining what potential issues could be raised by the adjudicator. I think what's really different about appearing in immigration court versus appearing before USCIS is that, USCIS, the officer is going to ask your client questions about these bars. So, you can be quite sure that they're going to dig into any military service. They're going to dig into firm resettlement issues. They're going to dig into persecutor bar issues. So they really have control, right? Like you're there with your client, you may interject, but there's not as much opportunity for the attorney or representative to actually be asking questions. And when you're in immigration court, I think it's more of a strategic question about how much do you want to bring out on direct examination versus waiting for cross-examination. I don't think that there's like a right or wrong answer to it, and it can often vary from case to case. What I will say is certainly when you're preparing your client, you should prepare them for the questions, whether or not you expect that you'll ask them, because you can expect that if you don't, that DHS probably will. So again, I would say this resource in terms of practice questions, particularly on persecutor bar issues, will be helpful. So make sure that you ask your client those questions, that you know what the answers are, and whether or not you decide to bring it out on direct versus waiting for cross-examination, at least the client will be prepared to answer those particular questions. The other thing that I sort of wanted to emphasize in terms of what is different about immigration court versus USCIS is how the exemptions to the material support bar are sort of processed. So we have, there's, as many of you know, a very broad ground of inadmissibility for those who have what they call engaged in terrorist activity, which is so broad that it includes situations that we certainly wouldn't think of as terrorism. And so because of how broadly the statute has been worded or phrased, there are a number of situational exemptions that USCIS has enacted over the past several years. And those include, this is not specific to Afghans, but those who provide material support under duress. So that's been sort of a long-standing situational exemption, what they call a certain limited material support. So it's incident to a routine social or commercial transaction, and then certain exemptions that are specific to Afghans for those who were employed as civil servants, or those who they call the Afghan Allies exemption, those who fought in a resistance movements against the Taliban. And so generally, when you have a client that is, proceeding on their asylum application before USCIS, has the authority to gather this information and then make a determination on whether or not to grant the trig exemption. If you have a client who is in proceedings before EOIR, the process is different and unfortunately more complicated and convoluted, I would say. So if an immigration judge makes a finding that a trig bar applies, the immigration judge actually cannot grant an exemption. They have to actually issue a final order of removal, and then in their decision, make a specific finding that they would have granted asylum, but for this trig issue. And then once that final order of removal, is received, or, then the ICE attorney actually has to make a recommendation to USCIS on whether USCIS should grant the waiver. USCIS will then issue a notice of a determination granting the exemption, and a motion to reopen has to be submitted to the court. So as you can see, this is really procedurally complicated because it involves 3 different agencies trying to coordinate. And you're also sort of relying on ICE OPLA, who maybe, was just your adversary in this proceeding, making a recommendation to grant a TRIG waiver. So it is quite complex to pursue those in immigration court. And again, just wanted to flag that as a potential issue to be aware of. Mona, I don't know, do you have any experience either with TRIG exemptions or, anything to add sort of on the strategic question about like, how do you address bars? Do you address them yourself, wait for DHS to bring them up, or what's kind of your thought process on that?
I mean, I think it just depends on what the bar is and how likely it is. So, for some of these firm resettlement issues, be prepared to answer the questions, but don't raise an issue that, that really when it really shouldn't apply at all. So it really, I think it's just fact based, making that decision. But I will say that someone mentioned to me recently that one of the IJs in her case had some this question of getting passports in Afghanistan. So this was an issue that was raised. The IJ was sort of like, how can it be persecution if your persecutor is giving you a passport with which you can exit the country? And the question of, are you paying for this passport? That sort of thing comes up and relates to TRIG. In that particular case, I'll just mention for what it's worth, that when this particular attorney made clear that the process to get the passport, first of all, that was sort of an incident civilian sort of exchange, and second of all, that there wasn't a lot of sort of interaction with the Taliban between the individual and the officials in order to obtain that passport, and that sort of assuaged the concerns of the IJ in that instance. So I think thinking through, whether it's the TRIG exemptions or just other bars, thinking about how you're presenting it really does become important.
Thank you. Yeah, this is an area where, again, there's like no easy or right answer. I think it's going to be case specific, right? And I think it's a good point that you don't always want to raise an issue if no one else is raising the issue, right? So again, prepare your clients, but if DHS says we don't think there's any bars, you could probably let it go, so. All right.
And there's also, and I would just also say that, there's ways that you can determine that in advance. So in advance of the merits, you're kind of wanting to already have that conversation with the DHS attorney. You're wanting to really get a sense of, what are the concerns if they're willing to have that conversation with you. So you're armed with, whether you need to write a brief on a particular issue or not, well before the merits.
Yeah, absolutely. All right, I'll think back to Rebecca, right?
Perhaps. Thank you, Mona. And I will add, my asylum client, who was fortunately granted asylum recently, was called back for an interview just for the passport. The wife had gotten a passport. But in the end, I don't know if there was a waiver involved. I wouldn't know if it was internally with USCIS, but I know a lot. Some people put in the chat, like asking about, did you pay utilities? Do your family still pay utilities? Do you send them money? So you get a lot of questions, I guess, in either context. But you got to make the call of how much information to include when you submit the application. But moving on, we're going to talk a little bit about the adjudication process. We've already gotten some questions about this with TPS. So how do you file for TPS one, and then how do you file for asylum? Let's start with TPS. So if you're if your client who's an Afghan and in this scenario is in removal proceedings, yes, they can still file for TPS if they're eligible. They file affirmatively with USCIS. It's kind of like a strategy call, and I keep promoting some of the great clinic material. So it's a really good practice point on TPS for folks in removal that hopefully one of my colleagues maybe can share in the chat. It is really great. But usually the overall strategy is twofold. One, for the most part, it's good to go ahead and file the TPS application if you reviewed the case and talked to the client and that's what they want, and then decide on a removal defense strategy that furthers your client's best interest. And that's something we're going to talk about in just a bit. Generally, there's no downside to applying for TPS when your client's already in removal. I know myself with a couple of Afghan clients that are not in removal, such as a former NDS officer who luckily was granted asylum. I was a little hesitant to file his TPS application because I was actually concerned that some of the direct questions on the TPS application would prompt USCIS to ask even more information about his background and use of weapon than the asylum officer actually asked. So I actually didn't end up filing his TPS application. That's just a note of caution, especially for folks who are not in removal. So again, you're going to want to know the facts of your client's case and have an informed discussion with him. And Mona, if you have anything to add to that, I see you nodding your head. It's just something to consider and where I want to caution everybody.
Yeah, that's a really good point. And I think I would just add that, you know, when you're looking at the bar issues, the other thing to consider is that the TPS application is a paper application. The asylum interview is an exchange and a dialogue and a question and answer. And in some instances, you're really more likely to be able to get the nuance out and to be more successful in the asylum context than it would be on the paper if those bars are a concern. And then just one other thing I would mention on the affirmative side is, you know, if you apply for TPS and your asylum interview goes forward, if you've gotten granted TPS, your asylum is, you're in the affirmative context, the interview goes forward and the adjudicator has a problem and would otherwise want to refer the case to court, then that may become a problem where they wouldn't refer you to removal proceedings if you do already have TPS. So in that instance, you know, you sort of, there are some cases where, you know, and even in the removal context where individuals may not want TPS because they want to move forward with the permanent form of relief as quickly as possible. But of course, they don't always know, you know, they may think that they have a really strong case, but that may or may not being the case depending on their judge and their circuit. So lots of different considerations there.
Yeah, exactly. I agree. And there's just two incidents where an immigration judge might review a TPS application. We did get some questions. One is if your USCIS denies your TPS application, you're referred to removal proceedings, or two, if the Administrative Appeals Office with USCIS dismisses your appeal and USCIS issues you an NTA, you would get a de novo review before an immigration judge. Also, folks who have a removal order can also apply for TPS if eligible, but it does not blanketly eliminate their removal order. Generally, if you have TPS and you're in removal, and let's say you have no other form of relief, the immigration judge will not terminate proceedings just based on that TPS. But there are some new regulations coming out where the judge will have discretionary authority to terminate proceedings. And one of them listed in the proposed regs is if somebody's beneficiary of TPS. So we'll see what happens with those regulations. And I know we're running up on time, so I want to really get to the most important points. So yeah, and I'll go back there just for a second, just for asylum. So everyone knows affirmative, no NTAs filed yet with EOIR, go ahead, file with USCIS. Defensive, you're filing with the judge in court. There's the asylum merits hearing. We're not going to talk about interview, which we're not going to talk about, but the two main routes are the affirmative and the defensive. So you can go to the next slide. Yeah, so the priorities, we talk about prosecutorial discretion a lot. We look at the Mayorkas memo from 2021 and then the Doyle memo, which lays out the priorities for ICE, the enforcement priorities of which non-citizens are a priority for removal and which aren't. There's three main priorities. The first is a threat to national security. That's where I was curious if ICE thinks your detained client Mohammed is some threat to national security. You know, if there's some other reason maybe you don't understand or know about behind why they won't release him, I don't know.
Yeah, just to to speak quickly to that, I mean, one of the major frustrations is this lack of transparency. And, working with your client, the ins and ideally, the ins and outs of their story, about the facts, what is problematic and what isn't, on the assumption that your client trusts you and you've built that strong relationship. And, I can't disclose additional facts about the client necessarily beyond what's already been reported in the press, but there really isn't, other than this EWI entry and that being a threat to border security. It's very frustrating. Yeah, the lack of transparency. Because also there's the CARP program, which is a program that's a whole nother conversation, that was discriminating against immigrants from Muslim majority countries for many years. Hallmark of that program at USCIS was this lack of transparency. And so you have people who are caught up and tagged as a national security concern, but it may just be some non-issue that, if the issue were disclosed, then the client and the attorney could resolve it and say, like, this person is not the same person that is on the terrorist watch list today, or, whatever other pretextual argument they have. But unfortunately, transparency is a major problem.
And that leads into, I'm just going to skip to priority 3, which is those who attempted to enter EWI after November 1st, 2020. There are mitigating factors, one of which is eligibility for relief, such as TPS, especially victim-centered forms of relief, such as the U visa or T visa. So you could try to seek prosecutorial discretion, even if the person entered after 2020, like Mona mentioned, but if they're eligible for relief, such as TPS, that might help make ICE more amenable. So let's go to the next slide, please. Thanks, Liz. So I just created this. So essentially what I'm getting at is when you're advising your Afghan client who's in removal and they're seeking asylum, do you want to exercise prosecutorial discretion, reach out to ICE OPLA and ask them to dismiss proceedings so that your client can file affirmatively with USCIS? Or does your client, or is it in their best interest to continue in removal proceedings and file and appear before the immigration judge? So here I just put different strengths, different things to consider, pros and cons of the different possibilities. Of course, affirmative asylum could be a much longer wait than in court. It just depends. You might want to consider the strength of the claim, adversarial setting, defensive versus non-adversarial, whether they're eligible for TPS, whether there's any potential bars, really putting together everything we've discussed today and having an honest, open conversation with your client. And then at the end of the day, if they do want to seek prosecutorial discretion, it's going to be up to OPLA if they want to join in that motion and exercise it. But I know our colleague Corey on the call today, her client is just, trying to seek prosecutorial discretion before an asylum merits hearing. And that was a, lengthy conversation I'm sure she had with her client to come to that decision, but it seems to be in the client's best interest. Yeah, so you can go to the next slide. So these are just some great tips. There's the Doyle memo. It has clear instructions to ICE, who's a priority, who's not. It lists the mitigating factors that you can include. There's a pretty new memo from EOIR that tells EOIR adjudicators, immigration judges, how to themselves implement these priorities, and really falls on DHS when they want to dismiss, which is concerning in that DHS wants to oftentimes unilaterally move to dismiss, even if you, the advocate and the respondent, your client, want to proceed. So hopefully judges will be much more amenable to listening to the other side, our side as counsel, and not dismiss where the client wants to proceed. Also, you should consult with your client, determine their objectives and goals. Do they want to stay in proceedings? Do they want to get out? And then you should reach out and just determine the local practice. Different offices might be more amenable to dismissing with a pending TPS, or some might say, look, you came after November 1st, 2020, you're a priority. We don't care, you got TPS, we're not dismissing. Or there might be some other reason, like in Mona's client's case, that DHS is just refusing to release him in that scenario. And in this scenario, they would just simply refuse to dismiss proceedings. And then lastly, I don't know if we're gonna have much time for this. These are just questions if you want to put briefly in the chat, if you've had much success with dismissals for Afghans, whether with pending or approved TPS, if you've had any success with getting for an Afghan client ICE to cancel, throw out an NTA to not file it with EOIR, that'd just be great for others on the call to know. And then if you can put the locality, the office, that would be wonderful. And I do want to get to the end because I want to get some of Mona's experience. So as Mona mentioned before, access to representation for Afghans. We need more representatives for Afghans, especially for those detained. You can check out those numbers yourself from the Immigration Law Lab. But we have a couple ideas here in our very last slide of the presentation. Where, if you can go to the next slide, Liz. So pro se clinics, I don't know if any of you on the call today have been part of a pro se clinic. I love pro se asylum clinics. I've run and volunteered at many of them. But these are just some considerations to have in mind. We put it here on the slide so you can refer to it. But I would love Mona just to jump in at the very end to provide some of her experience and advice as well.
Sorry, were you going to go through this or should I just go ahead and start?
I was concerned with the time if people need to jump off, so I figured any of your insight or going through the main
Sure.
point.
Yeah, just very quickly on the pro se clinics. HRF has done many pro se clinics in the affirmative context for OAR, OAW parolees, and done 2 so far in the defensive removal proceedings context. The main focus and the main concerns or the main needs that we're seeing is that people have a need for a change of venue motion to be filed. It's oftentimes they, get NTA'd one place, but they end up moving to a state, too far away to travel. So that's one urgent need. 1-year filing deadline. So filing a bare bones I-589 is really important, and they may not otherwise have a way to do that as they're trying to secure permanent counsel. And then oftentimes it's a requirement for shelters that you show that you've applied for asylum. So the focus has really been change of venue and the I-589 itself. And then the challenges or the concerns are, if you go much beyond the I-589, if you're now helping someone to, prepare their declaration, it can prolong the time frame, and with the nature of pro se clinics, that becomes complicated. But B, it also may be confusing to the IJ when this individual ultimately goes through pro se and they don't have an actual attorney. They haven't actually been prepared to give testimony properly by an attorney, but then they have this declaration that seems kind of obvious that it was prepared by someone else. So those are just some of the thoughts that, we are having as we think through pro se clinics in the defensive context. And then also just to note that most organizations, and, correct me if you know of any others where this is not the case, but most orgs that have been specifically servicing Afghan refugees over the last couple of years have really only been funded for the affirmative parolee context. So even when you have an Afghan who has crossed the southern border and gets paroled in with that 212 D5, you're still running into challenges with representation. So the work that we've done in the removal context has been through other funding not related to the Afghan. There hasn't been actual Afghan removal defense funding specifically. So this is a conversation that needs to evolve and grow. And since we're seeing many more Afghans who are coming through the southern border, this will be a great need.
Yeah, most definitely. Well, I want to thank Mona for being our guest presenter and the audience for being so active in the chat and the Q&A. And Liz, do you want to end it?
Sure, yeah, just echo that. Thanks to everyone. This was just a really great, rich, interesting conversation. I know I learned a lot. So let's all keep the conversation up and keep the good work up, everyone. Take care.
Thanks so much.
Thank you.